an individual has concerns about attending the hearing in person, the hearing will be televised live online via the following web address, millcreektownship.com/meetings. Only individuals who made prior arrangements are permitted to participate by telephone. I'd like to introduce the following people. We have Matthew Puzz, Zoning and Development Officer, Julie Maggio, Assistant Zoning and Development Officer, Rich Perhax, Board Solicitor, Cecilia Mahana, Court Reporter. After the presentation, the appellant, the board will hear from all interested parties in the appeal, whether in favor or in opposition to the appeal. After all presentations are made, the board will recess. We will then reconvene and make our decisions. The board has up to 45 days to render a decision, but most are made this evening. You may call the zoning office in the morning after 8:30 a.m. if you choose to leave before the decision is made tonight. I would now ask that everyone please stand to be sworn in. Do you swear to tell the truth, the whole truth, and nothing but the truth? Please answer, I do.
I do.
Okay, any information that you submit, we do have to keep for a minimum of 60 days. First on the agenda for tonight is appeal number 21-14, Reedman Companies for property located at 4601 to 4835 Idlebrook Village Drive, asking for a variance for an off-premise sign to be constructed at this property in the R4 High Density Residential District. Whoever's going to present, please go to the podium, introduce your name and your address.
Hello, my name's Jonathan Sack, 4511 McCreary Road, Erie, PA, 16506. Obviously, thank you guys for allowing us to speak tonight and present this. Obviously, we're looking for a variance for the corner of, or the bend of Old Zook Road and West Grandview. The reason for the variance is obviously our frontage for RWF Mill Creek, which is the owner of the Hammocks apartment complex. We only have 25 foot of frontage there. 20 foot of that is road. So meeting code and the setbacks, it pushes any kind of identifiable sign to identify the property or the road onto the property next door, which is also owned by Reedman Properties and its partners. We are obviously the managing partner of both complexes there, and would like to identify the property, as well as I think it'll promote safer traffic conditions around the bend, and that's what we're looking to do.
Now, when you said you have 25 foot of frontage, that's on Old Zook. You do have frontage on Zook Road as well?
Pardon me?
You do have frontage on Zook Road?
We have limited frontage on Zook Road. That is identified. Correct.
Okay. Any questions, Mike?
If this variance is not granted, what would you do?
There is another option that we could subdivide and absorb a piece of that property that would then become part of the parcel in question.
And how difficult would that be for you to do?
It's certainly more costly. This would be the most efficient way to identify the property, and but it wouldn't be impossible.
And right now you do own both properties. What happens if in the future you sell one of the properties?
We do not sell, we buy and hold. So that is not in the plan.
Is the sign going to be illuminated?
Pardon me?
Is the sign going to be lit at all?
I believe there will be some solar power lighting there.
Matt, do you have anything? No. Does the township have anything on this case?
Absolutely.
Hello, Matthew Waldinger, 3608 West 26th Street. I'm the Director of Planning and Development for Mill Creek Township. The township doesn't take a position on this sign one way or the other than to request to the zoning hearing board that if you do see fit to grant this appeal, that you would consider restricting the messaging on the sign solely to advertising the hammocks, the adjacent complex, and, you know, restrict it from being used for any other advertising as it is an off-premise sign. And then also, if the property were to be sold or either of the uses to cease, then the sign would have to be removed.
I do have a follow-up question. I don't see this as being I see this as being like a post and panel sign. It's not a message board sign, is it?
No, this is a permanent identification sign for the hammocks at Mill Creek.
So your point about messaging and all that would be moot at this point if it's a standard sign, is that correct?
Well, if an off-premise sign is permitted, we'd like it restricted solely to be this so that the panel couldn't be changed. You're right, it's not changeable in the moment, but it could be changed to advertise any other off-premise business.
Okay.
Anything else?
No.
Okay, we don't have anything else at this time. Appeal number 21-5, James Dumont, for property located at 5309 Millfair Road, asking for a use variance for a two-family dwelling in the RR Rural Residential District.
Thank you for allowing us to present our request. I'm James Dumont. This is my wife Pam. We've owned the property in question for 29 years, and I have submitted a number of documents tracing some of the history of the property. Specifically, this piece of property was one of the, if not the original, farm that was constructed in that area. And 50 years ago, it was converted to a 2-unit. I have documentation from Norman Brown indicating that that's when it was done. I have documentation from Sharon Carlin, who lives immediately to the south, that that's when the transition had taken place. In fact, when we bought the property, there was someone renting the front. One of the incentives for us in starting out to buy the property was because there was some income generated from the front apartment, but it had been long established, and to this point it's been 50 years. When we purchased it, we had to go through special financing because it was a 2-unit. We refinanced 1987, excuse me, and again, it was designated as a 2-unit. So what we're asking is for recognition that this is a 2-unit property.
I mean, I've reviewed, you obviously gave us a lot of very helpful information, appreciate that. And I've reviewed that pretty thoroughly. Mike, do you have some questions?
You're looking at correcting this because you're looking to sell the property,
That is
or?
cor-
Okay.
yes.
So this just goes back to one of these kinds of things that we've experienced over the years where the township changed some ordinances and now you've got to recomply to some things. Matt, what year was the zoning ordinance changed that impacted this? I'm asking the township.
we did research on this, back in 1970. That district, the RR district, or would have been the agricultural district, would have permitted two-family dwellings. But one of the requirements was that the lot needed to be at least, or have 100 foot of frontage. And I believe this lot has less.
But was it issued a building permit in 1970 when this was done?
No, we have no record of it ever being converted to a two-family dwelling.
This appears to have 110 foot of frontage.
100, and then the, I believe the ordinance was, and I apologize, this would have been out of this is an excerpt from the 1970 zoning ordinance. In the A residence district, a two-family dwelling may be erected, altered, or used on any lot if said lot has frontage of not less than 120 feet and contains not less than 14,400 square feet of lot area.
So the actual duplex use was permitted at the time it was commenced, but there were dimensional issues with basically whether the lot was big enough, so.
Correct.
But the actual two-family usage per se was permitted at the time it was built. Or at the time it was modified. Well, you just said it was.
Yeah, because I believe this was,
You just read it to me.
when was this? I apologize. Let me, I'm just looking at the year it was constructed per the county. This was built in 1920.
Well, it was, right, but the actual modification to create the second unit,
Would have been, yes.
1970, according to the evidence.
Correct,
That
correct.
the owner has. Okay. And at that time, you could have a two-family unit, but the lot wasn't big enough.
Correct,
Okay, I just want to understand the history of it.
yes.
Okay. I don't have anything else then.
I don't either.
Anything? Does township have a position on this?
Yes. Matt Waldinger, 3608 West 26th Street, representing Mill Creek Township. We do have some concerns with this because we have a feeling that the applicant does not have the evidence sufficient to sufficiently prove that at the time this was established that it was a legal non-conforming use. In their packet, they did submit a letter written in 1992 from the previous owner stating that the front of the home was turned into apartment in, and they handwrote 1970. Now this is a 29-year-old letter stipulating something that happened 22 years prior. And we did not feel that that was sufficient evidence, especially when compounded with the next letter, which was from a Miss Sharon Carlin, who stated at the very end of her letter that this has been a two-family dwelling since at least the mid-70s. The issue is that in this time period, the zoning ordinance did change a few times, and specifically when this was established and the size of the lot when it was established really matter as to whether it was a legal non-conforming use or not. As Matt said, in May of 1969, the zoning ordinance was changed to state that agricultural, which is the district that we're talking about that's now rural residential, agricultural properties would allow anything that was allowed in a residence district. And at that time, the A residence district allowed a two-family dwelling with 120 feet of frontage. This lot has 110 feet of frontage. And then following that in 1974, the ordinance was changed to restrict a residence to a single-family dwelling, and as such, agricultural was also then restricted to a single-family dwelling. So the time that this was established really matters, because of those guidelines as well as the size of the lot. And we just did not feel like sufficient evidence was presented in order to legally establish the use.
So does the township have an official position on this then?
The township would be opposed to this just because the evidence isn't here to allow us, and I believe, not to speak for Mr. Puz, but that would be the reason why he did not just register it as an existing non-conforming use.
Then what would the recommendation of the township be to these landowners who obviously are held up because they want to sell a piece of property? What would the township's recommendation to them be?
Well, legally, the only thing that could be done would be to sell it. It could still be sold as a single-family home. It was built as a single-family home, and according to all of the township and county records, it has been operated as such. I realize that, some evidence has been presented that there are 2 gas meters and 2 gas bills. There are 2 electric meters and 2 electric bills, which are, records of outside entities. As far as the township is concerned, when the sewer was installed on the property, there was a single tap placed for there, and they are only billed for 1 dwelling unit. They don't pay for 2 dwelling units. So like I said, in the entirety of the township record, this has been operated as a single-family home and could be sold as such. That is what is permitted in that zoning district.
But wouldn't that put a financial hardship on the owners having to reconstruct the home?
It potentially could, yes.
Okay.
Matt, has the township received any complaints from any neighbors in the area about the fact that it's a 2-family dwelling?
Not since I've been here, and that would be over 3 years.
Okay, thank you.
Is there anyone in the audience who would like to speak on this?
Got one over here.
Please go to the microphone and identify yourself. Thank you.
When we initially bought
You
this.
need name and address.
I need your name and address, please.
Oh, my name is Pam Dumont, and I'm the co-owner of this. When we initially bought this, there was none of this. When we didn't need a variance, we didn't need any of this. We just needed to have a statement from the guy, from Norm Brown. This is the Brown Farm that was turned into Millfair Heights. We just needed a statement from him for our mortgage company that it was a 2-family. There was no opposition back then. It's been well-maintained, well-cared for. We're loved in the neighborhood. And it's been that way for 50 years. And we would like to sell it. And we have a nice couple that want to buy it for the same reason that we bought it 29 years ago. So there was nothing, we would have done all of this work if we could have, but there'd been nothing from any governing agency prior to this.
I understand. Is there anyone else who would like to speak on this? Okay. To move on to appeal number 21-6, Carrie Peterson for property located at 2907 Garland Street, asking for a dimensional variance for the front yard setback along West 29th Street in the R1 Single Family Residential District.
I want to thank.
Hold on, please. Name and address.
Yeah, my name is Alex Peterson. I am the father of Carrie Peterson. I'm authorized to speak on his behalf. And this piece of property on the deed shows a 78-foot frontage toward 29th Street. The house sets back 44 feet from 29th Street.
Mm-hmm.
We want to add a 14-foot addition on the side of the house. That should leave 30 feet of clearance to 29th Street. I was talking to Matt. He gave me the aerial maps, and he said, Alex, unfortunately for you, there's an arch of property that the borough defines as being 10 feet inside your property line. So he says the net distance is not 30 feet, it's 20 feet. I was totally shocked by this. 14 feet is not very much. The home only has 832 square feet of living space. You can barely breathe in this home. We want to add 14 feet very simply to make a big living room. The width of the addition will be more likely 18 feet or even 16 feet, not even the 20 feet that's on the request. So I am seeking a relief from the 20-foot limit set by Matt, and I'd like to have approval for the 14 feet. Very simply, just give us living space. The area that we live in is an old development of Mill Creek. It's been around a long, long time. All the properties in the area have clearances to the roads, all in the whole area, of anywhere from 15 to 20 feet. If you walk or drive through any of the area that we live in, you'll see everybody is within 15 to 25 feet of their front street. And we feel that we will be in compliance with most of the residential homes in the area. And we will also add property value to the home. We really want to make it very presentable. We want to add character to the home. We want to, it's not on the request, but there will be a fireplace attached to the home, maybe coming out a foot, not 2 feet, just to give it some character, give a little bit of ambiance to the living room. And I hope that all of you can come to an agreement to let us have this 14 feet. Thank you.
Okay. My first question that struck me as I was reviewing all this previously, Matt, it says the issue is that's for the front yard setback. From the picture that I view, in the address, it appears though the front yard is toward Garland.
Since this is a corner lot, there's actually 2 front yards.
Okay.
And when there's a corner lot, you can have one that's 30 foot, one that's 20 foot. The one along Garland would be, since it's closer, would be the 20-foot one, which would make the one along West 29th the 30-foot front yard setback.
So it's a corner lot, but for a lot of intents, would you agree the front of the home is facing Garland Street? I mean, that's where the front door is and that's where the address is. I understand the zoning, I'm just asking a question.
I mean, if you define the front of a house as where the front door is, then yes, the front of
And
the
the
house.
address,
Yes.
okay. And then, so the issue, if I look at the arc of the road, their setback, because this plot plan was drawn on here, showing a 30-foot setback, but what it lacks is that the eastern part of the property, it's a 20-foot setback if you draw straight lines, but at a certain point it arches and goes out to 30 foot away from the home.
Correct.
So is there if I took a straight line on the northern line at the closest point, is that where it's 20 foot away, or is it closer than that? I don't know if that makes sense the way I stated it.
From the drawing that was submitted, this corner, which would be the northeast, would be the 20-foot.
So that's 20 foot from the furthest in part of the arc,
Correct.
but it doesn't, I guess what isn't really shown is that point there, by the time it gets to the home, that's not only 20 foot away, it's presumably 25 foot away or some other number.
Yes, the northwest corner would be 25 foot from the addition.
So Matt, what is the footage that's required?
30 foot.
30 foot, and you're saying that at the most critical point, there's only 20 feet.
Correct.
So it would be a 10-foot variance that would be being requested.
Yes.
At the closest point, though, I would say, and without having an engineer scale here, it's hard for me to say, but it would appear that it's not only 20 feet away. It's 20 feet, I understand your methodology completely. What you're saying is there's an arc.
There's an arc,
like
yeah.
this, right here. And at the closest point of this, if you drew a straight line, that's what makes the 20 foot. Is it not an average of the closest and furthest point?
When I took the average, I think the, geez. I apologize. I know where that's at too. When I took the average, it would have, I think it would have been, it was very similar to the 20-foot number.
But ultimately, we're going to need to know, if a variance is granted, we're going to need to know specifically either what the average is or what the setback requirement is, because it's important the way the paperwork might be written.
Right now I have 10 feet. That's all I have.
Right, because
So that's, if you granted it, that's what he'd get.
That's what
10
it
feet.
gets.
because if we truly measure from the northeast corner of the addition to the edge of the actual property line on the arc, it may very well be 27 feet, not 20 feet. Judging just by eye, I'm saying it's 25 to 27 feet. It's certainly not 20 feet.
Yeah, it appears as though if you granted him 10 feet, he'd be fine. He might not need 10 feet.
He doesn't need it if it was
Doesn't need it.
designed to this
That's-
addition point, yeah.
Because to Bob's point, I thought it was the average of.
I thought so too.
I thought if the arc goes southerly by 10 feet,
May I?
yeah, absolutely.
Okay, if you want to go off the record, because she's not going to be able to hear this chit chat up here.
If you gentlemen want to hear
Yeah,
what's going on because
yeah,
it's
why
your
don't you
case,
come up and
come on up.
You're entitled to see what he's,
Average, what I would do is I take this
yeah,
point.
you're entitled to hear
this
this.
point, and it creates basically a new front property line.
So what you're saying is the difference between this point and this point compared to a straight line is 20 feet.
Well, no, from the addition out, and I believe it's very similar to the, it's actually worse, what we call, and I have this, I did the calculations.
So I'm saying if we drew a straight line through here where they have it drawn, and this arc goes in, the dimension from here to here, if it were 10 feet, then that would all of a sudden average would be 25 feet. It would have to go in a full 20 foot for the average to be 20, if we're talking averages.
Because I always thought the corner lots was an average.
Well, it's an average between the two, but now we're talking irregular property
Right.
lines, which that's another average. So it's an average of an average.
But they may not require 10, they might require less than 10 feet with the averages.
Well, right, but if you give him 10, you know he's covered, if you're so inclined. I mean,
To be honest, do you need his paperwork? I don't.
No.
No, I don't need it.
Yeah, when I did it, I know it skewed it enough that it was actually less restrictive doing it this way.
Okay.
Yeah.
That's why I wrote it up to them.
Okay.
Okay.
Because I looked at it both ways to see which way made
Okay.
better sense.
okay, back on the record.
Okay.
Thank you.
I don't have any questions.
I don't, do you have anything?
I don't, I'm done.
Does township have a position?
Yeah.
Is there anyone else in the audience who would like to speak on this? Okay. We're going to take a bit of time here to recess and discuss these cases. If you'd like to wait, you can wait and hear if we render our judgment tonight. If not, you can call the township after 8 o'clock tomorrow morning. We're going to take a brief recess for now. Thank you.
I got the first one. I got the second one coming on the 11th of March. Pleasure. Rather than hand it.
Okay, I'd like to call the meeting back to order, 7:44. Regarding appeal number 21-4, do I have a motion?
I'd like to make a motion to approve 21-4.
I'll second that motion.
All in favor?
Aye.
Appeal number 21-5, do I have a motion?
I'd like to make a motion to approve Appeal 21-5.
I'll second that motion.
All in favor?
Aye.
Appeal number 21-6, I'll make a motion to approve.
I'll second that motion as well.
All in favor?
Aye. I'd like to make a motion to adjourn.
Second?
We are adjourned.
Adjourned.